Traffic Sergeant Andy Hernandez with a lesson on hit-and-run crimes, which is when you leave the scene of a traffic collision without performing the required duties. California Vehicle Code 20002, hit and run, misdemeanor, is charged when there is property damage only, and VC 20001, hit and run. Felony is charged if someone is injured or killed. Let's start with some sobering statistics from the National Highway Traffic Safety Administration. California leads the nation in hit-and-run traffic collisions with over 40,000 annually, 2021-2023. Of that, over 11% are fatalities. Only 1 in 5, 20% of these crimes are solved. Dr. Fields and I spent a large part of our careers investigating traffic collisions. I don't know how someone could run down another human and leave them for dead in the road. Okay, enough of that. Let's start with VC 2002, the misdemeanor section. The elements of this crime are in the statute and jury instructions, Cal Crim 2150, failure to perform duty following accident. Note that the police and insurance companies use the term traffic collision, however the law still uses the term accident. We do that because most collisions are not true accidents in that they are preventable, but that is a discussion for another lesson in the criminal investigations class. To prove the crime of 2002, hit and run, you must prove that 1. While driving, the defendant was involved in a vehicle accident. 2. The accident caused damage to someone else's property. 3. The defendant knew that they had been involved in an accident that caused property damage, or knew from the nature of the accident that it was probable that property had been damaged. And 4. The defendant willfully failed to perform one or more of the following duties. A. To immediately stop at the scene of the accident. Or B. To immediately provide the owner or person in control of the damaged property with their name, current residence address, and the name and address of the owner of the vehicle the defendant was driving. The driver of a vehicle may provide the required information in one of two ways. 1. The driver may locate the owner or person in control of the damaged property and give that person the information directly. On request, the driver must also show that person his or her driver's license and the vehicle registration. Or 2. The driver may leave the required information in a written note in a conspicuous place on the vehicle or other damaged property. The driver must then also, without unnecessary delay, notify either the police department of the city where the accident happened, or the local headquarters of the California Highway Patrol, if the accident happened in an unincorporated area. The duty to immediately stop means that the driver must stop his or her vehicle as soon as reasonably possible under the circumstances. For example, I often get people that remain in their vehicles blocking the traffic lanes after a minor fender bender. In those cases, you are required to move your vehicle to a safe space out of the traffic lanes. The driver of a vehicle must perform the duties listed regardless of how or why the accident happened. It does not matter if someone else caused the accident or if the accident was unavoidable. Failure to perform any of these three duties can result in a conviction. To be involved in a vehicle accident means to be connected with the accident in a natural or logical manner. It is not necessary for the driver's vehicle to collide with another vehicle or person. For example, if you make an unsafe lane change, which causes another driver to take evasive action and strike a third vehicle, you have been involved in a vehicle collision, accident. If you leave the scene of the accident without performing the required duties, you can be found guilty of hit and run. We call this a non-contact hit and run. When providing his or her name and address, the driver is required to identify himself or herself as the driver of a vehicle involved in the accident. Don't try to do the old switcheroo where the sober wife claims she is driving to cover for the drunk husband. An accident causes property damage if the property damage is the direct, natural, and probable consequence of the accident, and the damage would not have happened without the accident. A natural and probable consequence is one that a reasonable person would know is likely to happen if nothing unusual intervenes. In deciding whether a consequence is natural and probable, Consider all the circumstances established by the evidence. An accident causes property damage only if it is a substantial factor in causing the damage. A substantial factor is more than a trivial or remote factor. However, it need not be the only factor that causes the property damage. If the accident caused the defendant to be unconscious or disabled, so that they were not capable of performing the duties required by law, then they did not have to perform those duties at that time. However, they are still required to report as soon as reasonably possible. If causation is at issue, the court has a sua sponte duty to instruct on proximate cause. People v. Bernhardt, 1963. If needed, the court will provide the instruction on what defines driver and driving, as found in Calcrim No. 2241. Now let's discuss VC 2001 Hit and Run, felony as detailed in Calcrim 2140, failure to perform duty following accident, death, or injury. To prove that the defendant is guilty of this crime, the people must prove that 1. While driving, the defendant was involved in a vehicle accident. 2. The accident caused the death of, or permanent serious injury to, someone else. 3. The defendant knew that they had been involved in an accident that injured another person, or knew from the nature of the accident that it was probable that another person had been injured. And 4. The defendant willfully failed to perform one or more of the duties following duties. A. To immediately stop at the scene of the accident. B. To provide reasonable assistance to any person injured in the accident. C. To give to the person struck, the driver or occupants of any vehicle collided with, or any peace officer at the scene of the accident, all of the information required by VC 2002. And E. The driver must, without unnecessary delay, notify either the police department of the city where the accident happened or the local headquarters of the California Highway Patrol if the accident happened in an unincorporated area. To provide reasonable assistance means the driver must determine what assistance, if any, the injured person needs and make a reasonable effort to see that such assistance is provided, either by the driver or someone else. Reasonable assistance includes transporting anyone who has been injured for medical treatment or arranging the transportation for such treatment, if it is apparent that treatment is necessary, or if an injured person requests transportation. The driver is not required to provide assistance that is unnecessary or that is already being provided by someone else. However, the requirement that the driver provide assistance is not excused merely because bystanders are on the scene or could provide assistance. The driver of a vehicle must perform the duties listed regardless of who was injured and regardless of how or why the accident happened. It does not matter if someone else caused the accident or if the accident was unavoidable. A permanent, serious injury is one that permanently impairs the function or causes the loss of any organ or body part. An accident causes death or permanent, serious injury if the death or injury is the direct, natural, and probable consequence of the accident and would not have happened without the accident. So there you have it, the elements of the crimes of VC 20002 and 20001. I'm Traffic Sergeant Hernandez, and thanks for joining me today.